We begin our report with a unanimous decision from the Supreme Court over an issue that has divided the justices: abortion. The effect of the ruling is that the abortion pill Mifepristone can remain on the market. The judges could agree because the issue was a technical one, whether the case should be in the court at all. The matter was brought before the High Court by a group of anti-abortion doctors, challenging a Food and Drug Administration decision to expand access to the pill. In 2016, the FDA began allowing women to take Mifepristone between 7 and 10 weeks of pregnancy. In 2021, the agency said women no longer needed to see a doctor in person to get the pill. It also allowed pharmacies to ship the drug nationwide. The doctors argued these moves ignored safety concerns about using the pill later in pregnancy and would force them to treat resulting complications. Conservative Justice Brett Kavanaugh, who wrote the opinion, explained that the doctors did not meet the threshold for bringing the case. He said the doctors, quote, do not prescribe or use Mifepristone, and FDA is not requiring them to do or refrain from doing anything. Therefore, the plaintiffs lack standing to challenge FDA's actions. For more on this, let's bring in CBS News legal contributor Jessica Levinson. She's also a professor at Loyola Law School in Los Angeles. Jessica, great to be with you as always. What stood out to you about this ruling on both the issue at hand and also, was the court sending any signals to the lower courts that had previously ruled on this?
I think it is. I think it is sending a signal that the standing jurisprudence stands, that it is not going to undermine what is required for any person or group to walk into the courthouse doors. This is a very strong statement, as you said, a unanimous statement. Justice Clarence Thomas concurred, but he agreed with the outcome here, that in order to say, federal court, hear my case, you yourself have to be injured, not somebody else, not your neighbor, not your partner, not your friend, but you have to have that injury. And what the court said with respect to the doctors is, it can't be enough that you say, I might have to at some point treat somebody who has a rare side effect from Mifepristone. This is not a group of doctors that prescribe Mifepristone, and they are protected from having to treat somebody based on federal conscience laws, meaning if you have a genuine moral or religious objection to treating somebody by using Mifepristone, then you are protected from having to do so. And that's really what stood out to me, is frankly that it's somewhat remarkable that this case ever got to the Supreme Court, because it's a fairly clear application of the court standing doctrine.
And I've asked you to do it before, but I'll ask you again. Briefly, standing is a really important principle in jurisprudence. Remind people why it's important.
It's important because you yourself have to be the person that is injured when you go into court. It's the court's way of controlling how cases get brought before them. It's the court's way of saying, you don't get to say, you know what, I just don't really like what's happening over there or over there to those people. What you have to say is, I have an injury in fact. It was caused by the government action I'm complaining of. And if I win, then my injury can at least in part be remedied. So it is a procedural threshold that is in part every federal court's way of controlling who gets in the doors. And it's our way of making sure that federal courts only resolve true controversies and cases, not just giving advisory opinions. Here's what we hypothetically think.
Mifepristone remains on the market now. What other kinds of challenges might it face in the legal sphere?
So there is still this case, the remnants of this case that is pending in the trial court before Judge Kaczmarek. He did allow 3 states to intervene in the case: Idaho, Missouri, and Kansas. And so the case could continue with them as the plaintiffs. Now, the question is the same. Do the states have standing? And they're asserting a slightly different claim here. Their claim is that their interest in making sure that, for instance, they can ban abortions is undermined by the FDA saying, yes, you can obtain Mifepristone through telehealth. And what they're really arguing is that it's a federalism issue, that this infringes on state sovereignty. So depending on what Judge Kaczmarek says, this case could come back up again to the Fifth Circuit, and then again to the Supreme Court.
And finally, Jessica, the court hasn't issued its final word this term on abortion. There's still one case pending over Idaho's near total abortion ban. Remind us what's at play there.
So what's at play there? Completely different question. There is a federal statute, and it says if you come into an emergency room, then you are entitled to necessary stabilizing treatment. Separately, there is a state law out of Idaho that says you only get an abortion if it's necessary to save the life of the mother. And so the question is whether or not those two things conflict. Maybe an abortion is a stabilizing treatment, but it is not necessary to save that woman's life at that moment. And so what we're going to have really is something called a question of preemption. If the two things truly conflict, then we know what happens. Then the federal law wins. But that's the other big, quote unquote, abortion case that we're waiting for this term.
Jessica Levinson, thank you so much, as always. It was a day of unanimity on the High Court Thursday. Two other rulings came in at 9-0. The full lineup said the National Labor Relations Board had used too broad a standard in forcing Starbucks to rehire 7 Memphis-based workers who were trying to unionize their store in 2022. Starbucks had claimed that they were fired for other reasons. But the court's ruling focused not on the facts, but just on the standard, which may now be narrow in terms of the ability of the National Labor Relations Board to temporarily stop what it deems to be unfair labor practices. Also on Thursday, the Supreme Court ruled a political activist could not trademark the phrase "Trump too small." The phrase is a reference to a juvenile claim Florida Senator Marco Rubio, now on the short list to be Trump's VP, made about Donald Trump's anatomy in 2016. California attorney Steve Elster wanted to trademark the phrase he used to sell T-shirts, which list what he calls Trump's small positions on issues from the environment to health care. A lower court blocked him. Elster sued, saying he had a First Amendment right to the trademark, and the Supreme Court ultimately reaffirmed the lower court ruling that you cannot trademark other people's names.